Africa is the Secretary of State for the Home Department.
Yes, Mr. Hussain. We thought we ought to have a little bit of oral development of this rather complicated scenario.
My Lord, yes. My Lord, I say first of all, I appear with Miss Catherine Cronin for the applicant. My learned friend, Mr. Tim Iker, appears for the Home Secretary. We understand that my Lords have directed that they wish to explore the extent to which the grounds of appeal, in this case, have practical significance for the applicant. And, my Lord, our submissions will seek to focus on that issue of practical significance, though, of course, we'll seek to assist on any issue of interest to my Lords. My Lords will see that there are three grounds of appeal which seek to secure two practical things for the applicant. First, his non-removability, and secondly, his status, and in particular, his refugee status, whilst non-removable. The first two grounds, that is the vires of the Qualification Directive and the justiciability of refugee status on the not in accordance with the law ground, speak to refugee status. The third ground concerns non-removability, that is the issue regarding sufficiency of protection. My Lords, it is common ground between Mr. Iker and I that refugee status does indeed have practical significance for the applicant. He and I have had useful discussions in the run-up to this hearing. Indeed,
Yes, the contrast is between somebody who's here as a refugee and somebody who's here as an unlawful entrant who can't be sent away because of human rights considerations.
Yes.
The latter is in a pretty parlous situation, the refugee is in a better situation.
yes, or even if in the latter situation he receives some leave,
Yes,
that is inferior
yes,
to refugee status,
Yes.
as the Court of Appeal recognised in the case called Saad, which my Lord and
Yes.
my Lord Clark made.
yes.
And we have cited the Saad case at paragraph 9 of our application. So the main advantages in practice is that a refugee gets 5 years leave now. It used to be that he would get indefinite leave, but that's changed to 5 years. And that leave is reviewed after 5 years, but in the case of a refugee, the burden is on the Secretary of State to justify a cessation. If he is going to invoke cessation, then the oversight of the UNHCR is required, and refugee status, moreover, prevents exposure to something called special immigration status, a provision which is yet to be brought in, but that is a kind of immigration-only control order. It is a provision which permits certain immigrants who are undesirable, non-removables, if I can use that shorthand, to be simply tolerated in limbo in the UK.
But even at the moment, if you're an undesirable, non-removable, you don't have the same rights to employment, do you, as if you've got refugee status? There's practical significance.
There's very significant
yes.
practical differences.
Yes.
At the moment, on the authority of the Court of Appeal in a case called S, it concerned the Afghan hijackers, again, with which the court in Saad were concerned, albeit tangentially. On the authority of that case, there is no such thing as pure limbo status. If you're in the country and you can't be removed, you have to have your application for leave determined. It has to be either allowed or refused. But that's by the by. The point is that it's common ground. There are very significant practical differences as between refugee status and inferior forms of status.
So this is what pending refoulement, if refoulement's practically and legally possible, is it?
Yes.
Yes.
Yes. That's one way of putting it.
But if one considers what may happen at the AIT.
Yes.
The AIT might say that the presumption that he's dangerous is rebutted. It might say the presumption that he's committed a serious offence is rebutted.
Yes.
In which case he would not be susceptible to refoulement, and he would have his refugee status, and therefore these issues would not arise.
I see the force of that.
That's one possible outcome.
Yes.
Another possible outcome is that at the end of the day, it's held that there's no human rights bar on sending him back to South Africa, so off he goes. And again, the interesting issue about the incompatibility of the directive doesn't arise. And so one asks oneself, assuming that we were persuaded that there is an issue here that ought to be resolved, if it becomes material, wouldn't the sensible thing be to wait and see what the AIT does?
Well, that makes sense on the first point, post-Lisbon. Yeah. Before Lisbon it didn't, because no court other than this court, or the Court of Appeal arguably refusing permission, had competence to refer a question for a preliminary ruling to the Court of Justice pre-Lisbon. Yeah. And that was because of Article 68 of the EC Treaty as amended by Amsterdam. That placed a block on references in asylum matters arising under Title 4 of the EC Treaty.
So the AIT could refer the matters?
Now it could. It would be the upper tribunal.
Yes, the upper tribunal, yes.
It now could refer, and we see the force of the wait-and-see approach with regard to issue 1. Because it only arises if the certificate is upheld, the Section 72 certificate. Yes. As my Lord said, if we win on the Section 72 certification issue, then the interesting question of the vires of Article 14.4 and 14.5 of the Qualification Directive falls away. We did accept, before the Court of Appeal, I should say, that it was only the Court of Justice which had competence to pronounce on the vires of an EU instrument such as the directive for reasons of legal certainty and primacy.
If we refused permission at this point, on the basis that it'll be open to the AIT to refer, and the AIT for one reason or another didn't, would it then be open to you to come back to the Supreme Court with another application for permission?
We'd be able to go through the... we'd be able to access the appellate procedure. There is a wrinkle in the procedure in that the new appeal rules are far more restrictive than they were, so it's the second appeal point.
Yes. But you would argue that...
We would argue that there was an important point
get over your hurdles.
Important point of principle in compelling...
You can't show it's sufficiently compellable to justify a second appeal to the Court of Appeal. It's very difficult to see why we should grant permission here.
No, we accept that on ground 1, Lisbon makes all the difference. And if this case were only about ground 1, the vires of the Qualification Directive, then it may be that following December 09, we would have not been here. But grounds 2 and 3 make all the difference, we respectfully submit, because ground 2 is concerned with a question of municipal law on which...
Of what, sorry?
Of domestic law, municipal law, on which the upper tribunal would be bound by the Court of Appeal's ruling that the immigration-relevant provisions of the Refugee Convention, and by that I mean Articles 1, 32 and 33, have not been incorporated in domestic law so as to furnish the tribunal with jurisdiction to allow an appeal on the ground that the decision appealed against was not in accordance with the law. I'm sorry that's a bit convoluted.
It's which provisions again?
It's the not in accordance with the law jurisdiction of the tribunal that is engaged. Can I...
Is that referred to, actually, I know it is referred to, but is it quoted, the jurisdiction, is somewhere in your application?
What we've done, my Lord, I'm sorry, we were unsure as to how much material to burden the court with. There is a little clip in which we produced the relevant sections because they weren't clearly set out in any one place. And if I could just hand those up, Mr. Riker has a copy of these as well. If I can first take you to section 72, this is important because it shows you...
Are these not all in your document? Well, never mind, yeah.
I don't think they are, my lord, I'm sorry.
No.
What this shows, so section 72, what this shows is if there is assent, appellate assent with the certificate, then the tribunal is bound to refuse the appeal on a particular ground, and that particular ground concerns the compatibility of removal with Refugee Convention obligations.
Yes, well, that is in your...
It's in there. It's section 72.9a and section 72.10b. So it's removal centric, if I can put it that way. We say what that really goes to is Article 33 of the Refugee Convention, the prohibition on refoulement. It says nothing about Article 1, which is concerned with the definition of refugee status, and the Court of Appeal in the Sard case. We have the Sard case, my lord would like to see it. It's an important case, and it played a big part in the argument before the Court of Appeal. With great respect, it's not referred to in the judgment. But in the Sard case, this court held that there was, first of all, that there was an implicit duty in the Refugee Convention to determine refugee status. If you don't do that, you can't access the plethora of rights which the Refugee Convention contains beyond non-refoulement. It's all those rights between Articles 1 and 32 and 33. It's those rights which are usually in play because people are resisting removal. Yeah. But refugees are a special class of alien. And the beauty of the Refugee Convention is that 60 years ago, a plethora of benefits were conferred on a privileged class of alien. So there was an implicit duty to determine refugee status. And then more importantly, for our purposes, in the Sard case, the Court of Appeal held, it's at paragraph 48 of its reasoning, that issue was justiciable pursuant to the tribunal's not in accordance with the law jurisdiction.
Do we have that case, the Sard case, did you say?
We produced it because we thought it might be important. Again, I'm sorry if I should have done this before, but we
don't
contact the registry.
It's not clear to me to what extent this is in dispute, because they say, given that, they say Section 72 does not preclude the AIT from determining KC's immigration status, but I suppose it all depends what you mean by that.
Well, the Secretary of State has adopted what we say is a rather odd position. Position, because what he says is that the tribunal has power to determine refugee status, but no duty to do so. And we say if it's right that the Refugee Convention is non-incorporated, then it can't affect the rights and obligations of individuals in domestic law, and that means that the tribunal's power to pronounce on something which doesn't sound in domestic law is of limited, if any, value. We say that there is authority of the Court of Appeal to the effect that the non in accordance with the law jurisdiction of the tribunal, not the removal jurisdiction, the jurisdiction which speaks to the legality of the underlying decision.
Well, I quite understand all that.
Yes. Well, my lord, if that is, it's paragraph 48 of SARD. You have my lord's reasoning in the SARD case at 45. But if I can also, if my lords have SARD, I can take you very quickly through it. Paragraphs 2, 3, 4 and 9 speak to the proposition that refugee status confers benefits well beyond the protection against non-refoulement. 12 recognises that unless a refugee claimant can have access to a decision maker who can determine the refugee question, his access to convention rights is impeded. 16 is important because it says that absent a clear parliamentary indication to the contrary, we'd expect our primary delegated legislation to provide a system whereby claimants may have it determined whether they are refugees. It is only that determination which gives them access to convention rights. So you need a clear legislative warrant precluding the issue of refugee status determination. I'm not talking about removal here, status determination. The issue inside, I repeat, was whether or not the individuals were entitled to refugee status. There was no question of their removal. They had exceptional leave to remain. So it was squarely a status issue that was live in this case.
Well, this simply says that the tribunal has jurisdiction to determine refugee status.
Yes, but
Presumably it's only bound to do so if it's appropriate on the facts of a particular case.
Yes, but the basis upon which...
I mean, why hasn't this already been considered by the tribunal?
Oh, because the tribunal held that the Section 72 provision ousted the jurisdiction to consider refugee status, even though it speaks only to removal. I'm sorry if that's a bit Delphic, but I need to take you very quickly to...
So this was all argued before the tribunal, the SARD point, was it?
It was certainly argued before the Court of Appeal.
But not the, I suspect this point wasn't argued before the tribunal at all the first time round. Anyway, and it perhaps doesn't matter.
But isn't this point going to be academic in certain on certain hypotheses anyway? Supposing it's held that even if he's a refugee, he can be sent back to South Africa. How does the point matter then?
No, if he can be sent back, then the point doesn't arise. But we'll come on to that in a moment. But if he can't be sent back and he loses his challenge to the certificate, then the tribunal will be bound by the Court of Appeal to deny him refugee status. And we say that is wrong.
And is that an issue between the parties? Is that what the Secretary of State says?
Yes, because we say that the tribunal has a duty to determine his refugee status.
Yes, but is that the Secretary of State's
The Secretary of State's point is that he's got power to do so, but can't be compelled to do so.
Well, the tribunal.
Yes. The Secretary of State is saying that even though the issue of just refugee status is squarely live before the tribunal, it has no duty to determine it if the certificate is upheld.
What is the finding that has been held, or you fear would be binding in the Court of Appeal precisely?
It is.
Where do we find it?
You have it at the end of the judgment, my lord, at 113. It's the final sentence. If the tribunal finds that case committed a particularly serious crime, that he constitutes a danger to the community, he will not be entitled to refugee status, even if his convention rights, and what the court mean there are his ECHR rights, preclude his removal.
And that's a finding of the effect of the law.
Yes. Yes.
In effect, the finding of what the effect of the directive.
Yes.
Yes.
No, it's not just the effect of the finding directive. It follows from the conclusion of the Court of Appeal at paragraph 52 to 61 of the judgment that none of
This
the
is to say that the tribunal would not have jurisdiction, or if they would have jurisdiction, there's only one way they could exercise it, because they'd be bound by the Court of Appeal to exercise it in a particular way.
Yes.
I didn't read that into the notice of objection that we've got.
Well,
But we'll see in a minute.
Well, if it's
And surely this is based exclusively, as my lord suggested, on the qualification directive,
No.
isn't it? Well,
It-
that's recited earlier in 113. How can you separate it?
my lord needs to look at paragraph 31 to 33 and 34 of the judgment to see what issues were live in this case. And it's important to keep separate, for conceptual purposes, the qualification directive on the one hand and the Refugee Convention on the other. 31, the submissions on behalf of the appellants. The convention has been incorporated, albeit informally. That we took our lead from a dicta of Lord Bingham in the Roma rights case, in which he used that expression with respect to him. The submission is then recorded at C over the page. The effect of section 72 is to permit the country of refuge to refool, that is, deport a refugee. It does not deprive him of status. If the country is unable to deport, for whatever reason, refugee status is unaffected. In the case of Casey, he had a right to have his refugee status recognised. The tribunal erred in failing to find that he was a refugee. And then, I realise these are our issues. Then there is reference to the vires of the qualification directive. The Secretary of State submits at 32A, the convention has not been incorporated into English law. And then, rather Delphically, we respectfully submit, at H, submitted. And that's repeated in the passage to which my Lord Clark made reference. At H, he says, Section 72 doesn't limit the jurisdiction tribunal to find a person is a refugee. But, however, neither the convention nor the directive confers a right on an individual to have his refugee status recognised if the conditions for his refoulement under Article 33.2 of the former are satisfied. And that crisply summarises the issue in dispute. We say 33.2 simply deprives an individual of the protection against refoulement in 33.1. It does not deprive a person of his entitlement to have his refugee status considered. Because if it did, you'd be rewriting the convention, the refugee convention.
But I simply don't understand, in paragraph 113, that they've decided this point against you under the refugee convention as opposed to under the language of the qualification directive, because the whole paragraph is focused on the qualification directive.
Can I then
Question
continue?
whether the Secretary of State accepts that. Well, if he doesn't, whether we would then have to resolve it.
The fear you have is that there is a binding authority in the Court of Appeal in this case, and if I'm right in suggesting that 113 is limited to the qualification directive, there can't be.
Yes, but we'd be content to adopt that reasoning, but we paradoxically would submit that we can't. It may be that Mr. Iker submits that is left intact. But
well, it's not a question of what submits; it's what the judgment means.
Well, it's what the judgment means. Yes.
In deciding whether to give you permission to appeal, we decide what the judgment means.
We would have to decide that in a way binding on the parties at this hearing in order to determine that.
We don't normally do that.
No, that's my concern. I mean, my lords would normally give.
Well, if we refuse permission on a particular basis, then that would be binding.
Nice question. But one thing we could do is simply to adjourn this application to see what came out in the wash. And it would, at the end of the day, it would then be apparent precisely what was in issue on either side. First of all, whether this issue was actually a live issue at all, because it may never become live. And B, what stance was being taken in relation to it. I mean, the AIT may resolve the question of status, even if the Crown is right to say that they don't have to.
Well,
Well, the Crown would be saying that there's an issue estoppel on that point,
Yes.
created by the judgment in paragraph 113. That's what they would be saying if they were taking the point, wouldn't they?
Can I just throw another point into that? Look at the first sentence of paragraph 113. Surely it's obiter. It says it's strictly unnecessary to determine the questions referred to in paragraph 34 above, but I shall briefly indicate my opinion. Isn't that an obiter indication?
Well, there again, to my mind, it's important to discover what the Crown's position is about this, because then we'll know what points are live and what points aren't live. And I think we would have asked you what his position is.
If I can just develop my submission, I hope I'll come to showing, my lords, why the point's important. And perhaps I need to go to the governing statute rather than skirting around other judgments. The governing statute confers discrete rights of appeal based on the legality of the underlying decision, they're not in accordance with the law jurisdiction on the one hand, and the ground that removal would be incompatible with the Refugee Convention obligations on the other. The Section 72 certificate takes away the second ground of appeal. It says nothing about the first. That's the point.
Well, we understand that. We understand that.
The reason that's so important is because in the Sard case, your lordships, the Court of Appeal held that the issue of refugee status was justiciable on the former ground. And not justiciable, not simply conferring a power to determine, but a duty to determine it.
Yes. We weren't focusing on this particular area at all. We were just looking at the simple situation of somebody who arrives in this country, says, I am a refugee.
No, it's more, with respect, it's more complicated than that. It's someone who arrives in this country, says, I'm a refugee, he gets exceptional leave.
Yes.
So there's no apprehension or refoulement.
Yes.
Well, we understand
yes.
that.
So the issue, the Secretary of State submitted in Sard that all that Refugee Convention is concerned with is non-refoulement. So once you're not going to be refooled, you're not going to be removed, there's nothing upon which the ground of appeal would bite concerning removal. And my lord said, well, that would amount to finessing.
Well, that's very interesting. And assuming all that's correct, which it seems to me it is plainly correct, still the question arises, what the live issues in the tribunal are going to be this time?
Well, if you look at, if I go back to the Court of Appeal's judgment, if you look at paragraphs 52 onwards, what Lord Justice Stanley Burton concludes is that the Refugee Convention has not been incorporated into domestic law, despite what he describes were judicial pronouncements of the highest order pointing to the contrary. And you've got Lord Keating, Siva Kumar in 53.
Well, we had this in
you had it in
Asfor as well.
Asfor.
Yes.
And what we say about Asfor, my lord, is that Asfor concerned Article 31, which is a provision about immunity from criminal process. And that's why I said at the beginning of my submissions that the issue is whether or not the immigration-centric provisions of the Refugee Convention, that is to say Articles 1, 32 and 33, have been incorporated. We accept that Asfor is conclusive authority for the proposition that Article 31 hasn't. That's clear. But Articles 1, 32 and 33 are immigration-centric provisions, and there appears, at the very least, to be a conflict in Court of Appeal authority on the point, Sard on the one hand, this case on the other, and so we would say it's manifestly fit for leave. And the Secretary of State does not say that no question of general public importance is involved here. He doesn't say that there isn't arguability here. What he says is, I don't have jurisdiction because I won on my cross appeal. And the answer to which is the RB Algeria case.
I had some difficulty reading this judgment, which deals with points in the series without actually relating them, and I wasn't sure that this section was critical to the outcome.
This section is directly addressing an argument advanced by Mr. Gill for EN Serbia that the provisions of Section 72 were incompatible with the Refugee Convention. It was not an argument which was advanced by KC. But the argument which is dealt with here was advanced squarely by KC, Mr. Eichel will confirm this, on the not in accordance with the law issue, on the justiciability of the Refugee Convention issue, which is summarised at paragraph 34 of the judgment, as well as...
but if we adjourn it, or I suppose we dismiss the application, you will be arguing before the tribunal, will you, that the point is open before the tribunal, that they're entitled to determine it, and you would, if necessary, say that paragraph 113 is only about the qualification directive,
yes.
And or its obiter.
Yes.
Those would be your lines of arguments.
Yes, but yes, there's...
But you say that if the other side is saying they're not obiter, and if they're going to say to the tribunal, here is an issue estoppel in relation to it, then the Supreme Court should get on and decide it, because there obviously is a tension between SARD and the refoulement provisions, and that we should simply get on with it. So
yes,
much depends, to my mind, upon what the view, the attitude of the Crown is, or the respondent is.
Yes, which, of course, it would not bind anybody, what position the Crown took. One can't confer jurisdiction by consent. But we do say...
But it's common ground they've got jurisdiction.
I'm sorry?
It's common ground they've got jurisdiction, or would have, but for the paragraph 113.
It's common ground they've got power.
Power. Power.
Jurisdiction in that sense.
Yes.
But you'll be able to re-argue it, unless 113 is unfavourable to you, surely you'll be able to re-argue that they've not merely got a power but a duty.
Yes, but the
especially if we say, in making whatever we do say, doing whatever we do, we're doing it on that express basis.
The question is, the case having reached the high altitude of this court, whether this court should, in its discretion, if it's otherwise satisfied that the ground merits grant of permission, should refuse it on the basis that...
But whatever we decide, this case is going to go back to the tribunal, isn't it?
No. Because I haven't moved on to ground 3, and ground 3 concerns the issue of whether or not the tribunal erred in its approach to the question of sufficiency of protection. If the whether the Court of Appeal erred in its approach to sufficiency of protection. If the Supreme Court holds that it did and the tribunal did not, then the finding of the tribunal that KC's removal was not compatible with Article 3 would be upheld, and then the issue of refugee status would not need a remission, because the finding that he was going to be exposed to danger under Article 3, against which he would not have a sufficiency of protection available to him, would cover the same ground as would entitlement to refugee status under Article 1A2 of the Refugee Convention. And therefore, if we were successful on ground 3 and ground 2, we'd win. There would be no need for a remission. And ground 3, perhaps, is where the materiality or the practical benefit of this court taking this appeal bites most sharply, because what the Court of Appeal did on ground 3 is to say that this was a case which concerned the sufficiency of protection test as expounded by the House of Lords in the Horvath case and by the Court of Human Rights in Osman. And we say it was wrong to apply that approach, because that approach applies, first of all, to risks from non-state agents and nothing more. And secondly, it applies in the case of functioning democracies. Here, what we had was not a case of the persecutor being a non-state agent, but the persecutor being the state itself or people who are allied to it. The rather unusual history of this case, my lords will have noted, and it is the state that is in power now that was persecuting the applicant in the past. And that means that the test is not simply the Horvath test, but a test which was laid down in the Court of Appeal in the case of Savasas. It's altered. You have to have what Lord Justice Sedley called timely rectification of non-conforming behaviour. The other issue is that Horvath and Osman concerned functioning democracies. Here, the Secretary of State's own decision letter accepted that South Africa was a place where there had been a total breakdown in law and order, with risks from vigilante mobs which the police were not able to control, and very extensive police brutality as well. So this was a case.
Is that a description? Where do we find that?
Well,
it's not a description I recognise.
It's cited in my application without contest by Mr. Riker. You don't have the decision letter here. We've again produced it for you, and I can give you it if your Lordship would like it. It's in that bundle, but tab 3. And
in the new bundle, you mean?
yes, sorry, madam.
That's the directive.
Yes, so it's 5th of March 07.
Yes, it is. It's the new bundle.
We've got two new bundles. One new bundle hasn't got. Oh, I see. Yes.
So it's the new bundle I have. The loose clip. And you see what the position is in South Africa as described by the Secretary of State at paragraph 24 onwards. Consideration has been given to the redress available, and the State Department report is cited. Police service, which is overseen by the Department of State Safety and Security, has primary responsibility. The South African National Defence Force, which is overseen by the Department of Defence, is responsible for external security. The SANDF was in fact cited as an agent of persecution by Piers Pigu, the expert witness called by KC. He was the man who had described the fact that KC's testimony before the Truth and Reconciliation Commission in 1997 put him in a unique position. My Lords may recall from the papers that this is a man, that KC is a man who gave evidence before the Truth and Reconciliation Commission in November 1997 under police escort, and that his giving evidence was an event of international media significance. A BBC documentary was made about him, and a book has been written about his experiences.
I mean, I don't see anything here. I just think you use rather startling words about South Africa to say that it's not a functioning democracy. Obviously, it's got problems, but I don't think you could find those words here, can you?
No, we say there is a breakdown in law and order, yes.
Well, there are breakdowns, but to say that the country is not a functioning democracy seems
well, in the sense of
a total breakdown of.
No, sorry. What I mean is in the sense of having a criminal justice system which operates so as to punish criminals in a way that is commensurate with their wrongdoing, which is the kernel of the test in Horvath and Osman. Sufficiency protection against persecution or ill treatment is provided by a state where there is in place a criminal justice system which punishes wrongdoers commensurate with their wrongdoing. And that is not the position here. Because you have, and also that test is directed at pure non-state agents. At the end of 25, you have reference to members of security forces committing serious human rights abuses, 28 references to police being involved in violent confrontations and reference to rubber bullets, 29 deaths due to the use of excessive force by security forces and deaths in police custody were serious problems over the page. 31, Human Rights Watch reporting continuing police violence. 32, Freedom House noting that there was breakdown of law and order, serious problem. The country is ranked first in the world into the per capita number of rapes and armed robberies. 1 in 10 violent crimes results in conviction. Obviously, no system is perfect, but we say this is not the kind of place which the European Court of Human Rights had in mind when it was giving judgment in Osman, nor the kind of place which the House of Lords had in mind in the Horvath case. Horvath concerned the Slovak Republic, a nascent democracy. Osman concerned an internal situation where you had to show a real and immediate risk of ill treatment of which the authorities ought to have been aware. And that is the test which the Court of Appeal applies. My Lord, the President will recall that there are real differences, I'm thinking of the Lord Savile witness anonymity case, between the test of real and immediate risk and the test of real risk. And whatever, if I may say so with respect, whatever left of that decision in terms of, given the re-officer judgment of the House of Lords, that distinction is very much a sound one in law, we say. You don't need to show a real and immediate risk.
Only a real risk. Only
a real risk. But the Court of Appeal find that the tribunal had erred in...
You say if you apply a Chahal-type test, that's a real risk test, which is a lower test than the real and immediate risk test in Osman, although there's a certain element of dancing on the head of a pin about all this. The truth is that the courts have been narrowing or making more difficult passing the real and immediate test.
Yes,
as compared perhaps with the real risk
my
test.
Lord will recall that the Libyan case, AS and DD, which my Lord Lord Clark heard, just after the Grand Chamber had given judgment in the Sadi decision, my Lord looked in detail at the genesis of the substantial grounds for a real risk test first laid down in the Surin case. But yes, we say it's a lesser test than the Osman test. The Osman test is a test about positive obligations as concerning the operation of a police force. It speaks to operational failings. It has nothing to do with a situation where a state is expelling an individual. Indeed, in the case of Pretty, Lord Bingham noted how the situation was different in an expulsion case, where the expulsion itself would be said to be the treatment in Article 3. And my Lords, again, will recall the Q case, which is the predecessor of Limwella, about Section 55 support. I'm sorry if I'm going off at a tangent, but that was the case where the state had entered the arena. And because it entered the arena, the negative obligation under Article 3 had been engaged. We say expulsion means you enter the arena and negative obligations engaged. There's no warrant for the real and immediate test. No court has applied that. And the Court of Appeal were very wrong to say, with great respect to them, that the tribunal had erred in not applying a real and immediate risk test. And if we went on that...
What test did they apply?
Well, what we say the tribunal did is to look at the particular profile of the...
Where do we see that formulation of the test?
We accept that the tribunal's reasoning is exiguous. We accept that.
Well, that's why it looks as if whatever happens, despite your submissions a few minutes ago, there's every prospect of the thing being remitted sooner or later to the the tribunal.
My Lord, with respect, no.
Because if even if they applied the correct test, if they didn't give any sufficient reasons, well then...
Well, except, of course, it would be open to the courts to find, and the submission would be pressed on the court, that this is a case which is very unusual, where what the tribunal found was, in effect, that this man was in a unique, a special, if not unique, position, as evidenced by what happened when he went back to give witness evidence, as evidenced by the fact that he was the target by very senior members of the ANC of ill treatment in the past. and therefore only special measures of protection.
So where do we see the test stated by the tribunal?
I've just lost my notes, I'm sorry. I'm sorry, my lord, I've just mislaid my note. I'm sorry, Ms. Cronin helps. It's at 63 of the conclusion of the tribunal.
The tab. Which tab are we in?
You're in
Tab 5.
Tab 5.
Five. Yeah.
This is differing from the first instance tribunal, isn't it?
Yes.
I mean, we've got a situation where, in fact, there are two opposing assessments of whether there's a real risk of serious harm in South Africa.
Well, no, there aren't, because it's common ground that he would be at real risk of harm.
Well, it wasn't in the first instance tribunal. They said...
Yes, but that decision is superseded by the decision that was...
In this decision, they said that the reasoning of the decision of the first instance tribunal was perverse.
Yes, and the assessment of risk was not challenged before the Court of Appeal. So there aren't two different assessments of
I
risk
see.
at all,
That's right.
with respect. And they say that the risk of harm has been fully established, so this is not challenged. What wasn't challenged before the Court of Appeal plainly isn't challenged now. It's been fully established in the material we've set out above. Without detracting from the generality of the information viewed as a whole, we consider the following material as persuasive. The TRC findings, the fact
So they just asked themselves whether there was a risk of harm.
well, except at Roman 5, they say, in the event of threats, there is likely to be inadequate protection, and then they refer back to 20 and 27, and that is where they summarise the evidence of Piers Pigu and Mr. Bridgeland, Fred Bridgeland, who was the journalist with whom Casey collaborated in writing his book. Paragraph 20 you have at page 8 of the judgment. Mr. Pigu points out that neither Mrs. Mandela nor other members of the football club have been questioned or charged about other credible allegations of misconduct. He accepts the South African authorities might try to afford some protection to the appellant if he were threatened or intimidated. He advocates, however, a sense of realism. Whatever witness programme currently exists, he considers it is likely to be very limited. And then at 27, this is a reference to Mr. Bridgeland's evidence. He points out the appellant was given special police protection for the period of his return to South Africa in recognition of the risk that he faced of attack. He was provided with a safe house to ensure his safety and quickly taken out of the country after he'd given his evidence, etc.
What was Mr. Pigu's expertise and ability to speak to the likely protection?
He was the rapporteur of the Truth and Reconciliation Commission.
But how does he know whether the police would be likely to afford protection? They did on a previous occasion, didn't they? So yes. That's maybe a matter of fact.
Yes, his credentials are summarised at paragraph 12. No challenge has ever been made to his expertise. And you'll see he was employed as an investigator by the Johannesburg office of the Commission, was responsible for investigating a number of incidents involving events in South Africa's past conflicts. Primary investigator into the allegations against Mrs. Mandela and the Mandela United Football Club, intimately involved in the open in-camera hearings, etc. So he was peculiarly well placed to understand what we say is the uniqueness of the position in which KC would find himself were he to go back, or the extreme peculiarity of it. And my lords will have the elementary proposition that sufficiency of protection and risk are, if not two sides of the same coin, then very close to it. Of course, what is adequate protection turns on the level of risk. This is a man who was at high risk and whose claims as to risk the tribunal found were fully established. But even if an appeal to this court would not be dispositive of the refugee status claim, the Court of Appeal's ruling on sufficiency of protection would, of course, not only bind the tribunal, but bind the Court of Appeal. So it'd be very difficult to see how we would get a challenge to the sufficiency of protection ruling to this court were the case to be remitted. And at the beginning of my submissions, I said that KC seeks to secure two things. First of all, non-removability. Secondly, refugee status. This ground, the third ground, the sufficiency of protection ground, goes to the non-removability issue. And it is something which we would respectfully submit should not be remitted back to the tribunal unless this court finds that it doesn't meet the usual tests for permission. It wouldn't be appropriate.
You're saying there should be an appeal to this court in order for us to decide the question whether there would be sufficiency of protection.
No.
Effectively, no. Or you say that's been decided.
No, this court doesn't do that. Of course, my lord. This court would decide what the appropriate legal test was and whether or not the Court of Appeal had erred. And I would be submitting, A, the Court of Appeal erred, and B, on the correct test, you could only have one possible outcome. But if I lost on B, I would still secure a material benefit for my client under A.
That would argue this argues for having an appeal now.
Yes, yes.
And this is on your present submission.
Yes.
Not necessarily, however, referring it to the European Court now.
Oh, no. The reference question only arises under ground 1.
Yeah.
Grounds 2 and 3 are questions of domestic law on which the Court of Appeal would bind itself and the upper tribunal subject to what is said about ground 2, but on ground 3 it would bind.
But doesn't the question which test applies depend upon a proper understanding of the facts? In other words, if one was dealing with a state which, as far as it was concerned, was doing its best to afford proper protection, but the system wasn't working perfectly, one might be in an Osman-type case. There would have to be some real and immediate notice in the particular case that the system wasn't going to work. Whereas if one was dealing with a state which had no proper system at all, and certainly ought to know that, then one might, as you submit, be in the Chahal case where the only question is whether there's a real risk of injury. And the difficulty is that, according to the Court of Appeal, we simply don't have sufficient factual findings, as I understand it, or a sufficient determination of what the facts are to even start to apply any test. I think that, the Court of Appeal in paragraph 109 is putting it on the basis of insufficient reasoning. It doesn't appear the tribunal applied a correct legal test, or indeed that the tribunal addressed appropriately the factual contention. So the Court of Appeal is really saying everything's up in the air, and to expect this court to decide which test applies without a sound factual foundation may be wrong.
Well, that with respect, is the Court of Appeal's view. It's a view which we would seek to displace. I can see force in the insufficient reasoning point, but as far as the failure to address appropriately the factual contentions put forward by the Secretary of State, what the Court of Appeal is talking about is the refusal letter, and I've just shown you that. We say that the failure to look at what the Secretary said in his refusal letter was entirely non-material, because what was said in the refusal letter availed my client.
Well, there's a lot in the refusal letter which suggests that things may have improved as well as got worse. I mean, there have been reforms in 2005 and the number of deaths in custody had gone at halved and so on. There's a lot which more than the bits you read.
Sure, but my Lord, may I say so, but we say that it is difficult to see how how the material to which I did point could bring this situation into the normal Horvath-Osman situation where one is concerned with nascent democracies.
When this comes back before the AIT, first of all, the AIT will consider the position in South Africa as it is at the time that they are reaching their decision.
Yes.
Secondly, it's possible that they might say, whatever the test, you satisfy it. It's possible they might say, whatever the test, you don't satisfy it.
Yes. But it may say that we ask ourselves the question, is there a real and immediate risk to the life of KC? It might say that because of paragraph 108 of the Court of Appeal's judgment. And that is something we say is fundamentally wrong. And this court is the only court with power to correct that.
Well, is that right? I mean, if again, I mean, it slightly depends on perhaps on the Crown's Secretary of State's attitude, but it may also depend on how we deal with the matter. If it's made clear one way or the other that there is no binding determination as to which is the right test to apply in the circumstances, because it does all depend upon the circumstances, then you'd be content, wouldn't you?
That is never the test. The real and immediate risk test has been lifted from Osman, which is concerned with an internal situation about police operational practices, into a very different situation of expulsion and risk from non-state agents. And we say that's never the test. It is the real risk test.
Although in Horvath, I mean, Horvath was this class of case, wasn't it?
Well, it's an expulsion case, yes. Yeah. It's a refugee case.
And according to Lord Clyde, quoted at paragraph 105,
yes.
There are, at any rate, some circumstances in which the Osman test applies in the expulsion class of case, because the House of Lords applied it.
But
or at any rate said that it was applicable.
But what Lord Clyde takes from Osman is the idea of a system of domestic protection and machinery, which in general would protect. He didn't say anything in Horvath, and nor did any of the other of their lordships say anything about the threshold test which must be passed to engage what is required by way of protection. The focus was on simply the protection issue.
I find it very hard to see in principle why the threshold test should differ.
Yes.
Really?
Yes. We're not talking about positive obligations here.
No.
This is state action. And it's the
But it's said that the threshold test does differ, or may differ, depending upon...
The Court of Appeal appear to proceed on the basis that it does. And we say...
You say the Osman test is never applicable, do you?
In an expulsion context...
And that Lord Clyde didn't say it was?
No, he didn't, and leave alone the situation where you've got quasi-state agents persecuting, or rogue state agents, members affiliated to the ANC who are loyal to Winnie Mandela. Leave aside that. Leave aside the underlying nature of the state, whether or not it's a functioning democracy or not. That's not the test. And there's the case of HLR in France held that in the Article 3 context you could have risks emanating from non-state agents. That was a case about risks from drug traffickers in Colombia. And what the Strasbourg court held was that what you had to show was substantial grounds for real risk, the Turing-Chahal formulation, against which there was no adequate protection. And it's that adequacy of protection which the Horvath authority speaks to. It is not that the threshold changes. And if that is right, then this court, we say, ought to grant leave, because the Court of Appeal appear at paragraph 108 clearly to have accepted the proposition that the tribunal ought to have looked at that immediacy criterion as well as the reality criterion of risk.
What do you say about the last paragraph of the quotation from Lord Clyde?
Yes, my Lord, that's very interesting, because we say, what Lord Clyde says, that it will require cogent evidence that the state which is able to afford protection is unwilling to do so, especially in the case of a democracy. And what we say is that the converse proposition is nothing like as strong, namely that there may be a willing state that is unable to provide protection.
Yes, but I mean, he's saying that a willing state unable to provide protection is different from an unwilling state. He says that in the first sentence. So that's the distinction, isn't it, between the Chahal type case and the Osman type case. He says inefficiency and incompetence is not the same as unwillingness. And corruption, sympathy or weakness of some individuals in the system of justice doesn't mean the state is unwilling to afford protection. Personally, I would have thought that there must be a strong argument for saying that is the position in South Africa. As in, I fear, many African countries and other countries.
No, but the focus here is on unwillingness. Your Lordship will recall that Article 1A2 says a person is a refugee if they have well-founded fear of persecution and they are unable or unwilling to, and protection, the state is unwilling or unable to provide protection. And this is focused on unwillingness.
But standing back, we're looking at a category of case which Lord Bingham described as foreign cases, cases where what you're concerned with is what may happen to the applicant in a foreign country.
Yes.
And Strasbourg having opened the door to these considerations, is then making sure that the door doesn't open too far.
Not in Article 3, my Lord. But my Lord has in mind the flagrancy test that it's applied to the second and third tier of convention rights.
Article 6 and so on,
5, 6, 8, forget about domestic cases, but 8, 9, 10, 11.
Yes.
There have been no cases ever decided under 9, 10, 11. 9 was the Euler case, which my Lord will recall. 5 and 6, my Lord will recall, were the Ottoman case.
Yes.
The Algerian Ottoman case, the Jordanian case. But no, in Article 3, no flagrancy test is applied at all.
You say if you throw in immediate, you're actually applying a flagrancy test.
Yes, that's one way of putting it. And the justification for the application of the flagrancy standard it is that there is essentially, one can look at it like this, there is a 3-tier hierarchy in the convention scheme. You've got, first of all, the rights which are non-derogable even in time of war or public emergency, and those are 2, 3, 4, slavery, and 7, retrospective criminal penalty. They are non-derogable, and they apply without a flagrancy gloss to the expulsion context. You then have limited rights, 5 and 6, and then you have the qualified rights, 8 to 12, and they apply with a flagrancy threshold applied on top of the rights themselves. And we are concerned with Article 3. The risk is that this man is going to be killed or subjected to very serious ill treatment, 2 or 3.
Yes, well, I think we probably have a clearer view of your side of the argument, anyway.
Thank you very much,
My Lord, I can perhaps take the grounds in order. My learned friend accepted that in relation to ground 1, the reference question, if I can call it that, the absence of Article 68 of the EC Treaty now makes a very real difference in that the tribunal can now make a reference if that is necessary, and there's of course the treaty makes clear references should only be made if that is necessary to determine the case before the court. In this case, the two questions, namely refouleability and refugee status. And in our respectful submission, there's now no real benefit for this court making that decision, because that is open to the tribunal on the basis of findings of fact, and will of course only arise, as all three grounds will only arise, if my learned friend does not succeed on section 72, i.e. to rebut the two presumptions, and therefore get himself out of the Article 33 issue altogether. In relation to the second ground, and I'm more than happy to elaborate on that if your lordships require me to, but in relation to the second issue, that takes us back to paragraph 113 of the judgment, and I noted that particular interest as to the position of the Crown was expressed when that was debated. Now, the Secretary of State reads that paragraph the same way as my Lord Mance reads it, namely that it makes clear in the first line that that is wholly obiter, because it says it is strictly unnecessary to determine the questions referred to in paragraph 34 above, and we see that those are the consequences of the application of Article 33 to a refugee who seeks to be recognised in a case in which he cannot lawfully be refooled. So it seems, again, the position of the Secretary of State is, this is in my printout, certainly on page 13, my Lord, but the printout may be a different one. So it's paragraph number 34. And it is with that issue and the Secretary of State's position as previously expressed, namely that while there is, in relation to a removal decision, no duty on the tribunal to find whether an individual is a refugee, there is nothing in the legislation that prevents the tribunal from making such a finding if, in the circumstances of that case, it is necessary and or appropriate. And on that basis, and in light of the fact that the Court of Appeal has, of course, remitted all issues for a fresh determination on a secondary consideration to what is now the Immigration and Asylum Chamber of the Upper Tribunal.
Only issues of fact, though. Is that right? I mean, is it on the true construction of the order? It doesn't include all issues, because the Court of Appeal has presumably determined some issues.
My Lord, it has given guidance on some issues, but of course the fundamental issues were the application of Section 72, which has been remitted on all bases to go back to be read in light of the guidance the Court of Appeal gives on Section 72, and the fact that there's now the ability to, contrary to what appeared on the face of the statute, the ability to rebut both presumptions. And they have remitted the question of returnability and the issue of the Horvath question, if I can call it that, which is covered by Ground 3.
Yes.
But it's really a question of whether the last sentence of paragraph 113 is a conclusion of law, isn't it? Or at any rate, partly a conclusion of law.
My Lord, that is certainly not how the Secretary of State read the last sentence of paragraph, because it concludes a consideration of something which Lord Justice Stanley Burnton expressly says it is unnecessary to determine, and he then goes on, I shall briefly...
It may be obiter, but it's a conclusion of law.
It is a conclusion of law, but it certainly is, we would respect...
So you will concede before the tribunal, will you, that it is open to the tribunal to reach a different conclusion, inviting that they would have power, and in some circumstances a duty to reconsider the correctness of the last sentence of paragraph 113, notwithstanding the decision of the Court of Appeal. Is that right?
Well, that's certainly the
I can't help feeling that when you actually get before the tribunal, it won't sound quite like that.
No, if you've made it clear, I'm sure it will sound like that.
My Lord, I make that submission before this court, and I don't anticipate that I will be personally before the tribunal when this comes back, but that is the position of the Secretary of State as expressed to the highest court of the land, and that's, Your Lordship asked for the reading of the Secretary of State. But again...
Well, the Secretary of State would clearly be precluded, if you take that line, from taking any other.
Yes.
My Lord, yes. And it is, again, on that basis that we would respectfully submit that there is no real benefit of remitting issue, of entertaining issue 2 now, or the ground of appeal now, or at all, because it can squarely be determined by the tribunal or by the Immigration and Asylum Chamber when it returns there. And of course it is in the interest of the appellant that happen sooner rather than later. One of the big issues, of course, and with the reference question having become secondary, that's perhaps not quite an issue anymore, but the appeal has not gone back to the Immigration and Asylum Chamber, pending the determination of this decision and any possible reference and the like, which of course prevents the tribunal from making the findings which may enable this appellant to get refugee status sooner rather than later, or at least confirmation of his non-returnability. In relation to the third issue, in our respectful submission, again, it is important to look at what the Court of Appeal found, and in our respectful submission, the starting point for the Court of Appeal's analysis is Osman and Horvath, which we see at paragraph 104, 105, and 106. And of course, one of the important aspects of my learned French submissions in relation to Horvath is that he sought to distinguish it on the basis that that case was concerned with non-state agents. And again, there may well be a very real dispute about facts, or on the facts here, because the tribunal, in its short reasons in paragraph 63, Roman 7, adopted and quoted views expressed by correspondents within the government, one of which said the risk to the appellant's safety comes not from the government there, but from supporters of Mrs. Mandela who would no doubt wish to see him silenced.
Sorry, which paragraph was that?
This is paragraph 63, to which my learned friend,
yes,
Your Lordships, and it's Romans 7. In italics, there is quote from correspondence within government which the appellant obtained through a Freedom of Information Act request. And about 6 lines from the bottom, yes, Your Lordship will see the risk to the appellant's safety.
Yes.
And in the opening lines, the tribunal makes clear the fact that our views are clearly consonant with the view expressed therein. And of course, that question of fact is not one which, in our respectful submission, it is for this court to resolve, but it's one which only the tribunal or the chamber can resolve. And if the analysis of the tribunal is right, and it is not state agents, in our respectful submission, there is then in Horvath binding House of Lords authority, which sets out the test in the language set out at the end of paragraph 105. In the quote, this is the paragraph at the end of the paragraph above the quote, there must be in place a system of domestic protection machinery for the protection, prosecution and punishment of actings contrary to the purposes which the Convention requires to have protected. More importantly, there must be an ability and a readiness to operate that machinery. Precisely where the line is drawn beyond that generality is necessarily a matter of the circumstances of each particular case. He then quotes with approval the formulation presented by Lord Justice Stuart Smith in the Court of Appeal, and then goes on to the paragraph my lords took my learned friend to. And in our respectful submission, again, the test that the Court of Appeal then set out is at the beginning of paragraph 107 of its judgment. That it cannot be the case that this country would be in breach of its obligations under Articles 2 or 3 if the state to which a person is to be returned would not itself be in breach of its obligations under those articles if that state were a party to the European Convention. And that goes to the real and immediate risk, which is, of course, if that can't be established in South Africa, or if that couldn't be established here, if the whole scenario, factual scenario took place here, there would be no breach of the Convention by the United Kingdom. And all, again, we would respectfully submit, the Court of Appeal was finding there that that standard needs to be applied when one looks at another country before then considering the test under Article 3, the real risk test that arises from removal to that country. And insofar as my learned friend refers to functioning democracies, of course, Horvath was concerned with Slovakia and Romas in Slovakia at a time where it would have been as easily possible to say Slovakia is not a functioning democracy as we would respectfully submit it is today to say that South Africa isn't such a functioning democracy. They had, all of them had their, and are having their teething problems. But that, again, is a question of fact rather than law. We would respectfully submit more appropriately determined by the Immigration and Asylum Chamber rather than by this court on an appeal now.
So 107 is dealing with the existence of system, isn't it? Because
My Lord, yes.
there can be individual breaches of Article 2 or Article 3.
My Lord, yes.
And so that's the second stage. If the system's in place, is there a real and immediate risk that the system will not work?
Well, the test is as where there is a system, is there real or immediate risk of which the authorities are or should have been aware of, and in relation to which they should have responded in a convention-compatible manner. And what the Court of Appeal says in our respectful submission is the test that is applied to the system in South Africa, when one looks at it on removal, cannot be higher than the test that would be applied if one looked at the Metropolitan Police.
The distinction in drawn in paragraph 105 seems to be between a state which is unwilling to provide protection and one which incompetently fails to provide protection.
My Lord, yes.
And one question which may arise is at what level of generality you ask that question.
My Lord, yes.
I mean, no doubt here it would be said, it might be said here, well, the particular circumstances of this particular applicant lead to the conclusion, to the inference that the state was not willing to protect the KC. It may have had a system which is good for some purposes. If my lord or I went there, we'd probably be able to look tight all right after. But you know, this Mr. KC has got a lot of enemies there. And the evidence shows that the state isn't going to lift a finger to help them generate in the short term.
My Lord, that may well be right, but of course that is in a sense something which is...
But what I'm saying is that if that were, if it was an unwillingness case, then query whether the Osmond test would be appropriate. And what the Court of Appeal has done has sort of elided those two questions in paragraph 105 and 106.
My Lord, yes, but it has done so on the basis of the facts that were before it, which were, as I read the facts before the tribunal, the suggestion was that he was subject to a very well thought out and detailed witness protection programme when he went back to give evidence. He will not be subject to that level of protection when he returns, or if he returns. But I certainly didn't read the evidence that there is going to be no protection at all. It is about level of protection.
Well, one would have to read all the evidence to discover that. I mean,
Lord,
the paragraph you referred us to, I quite take your point in relation to the end of little 7. But one would have to look at a lot more of the evidence to see.
If this goes back on this point, would there be scope for more evidence? I mean, there would, as my lord said, updating.
My Lord, yes, of course, the position would have to be considered as at the time at which the matter is to be, or at which the matter is determined by the tribunal.
And the Court of Appeal was really saying that when it said the reasoning is inadequate. It was also contemplating and inviting further evidential inquiry.
It was certainly inviting a fresh analysis of all the evidence and inviting, though not expressly, but inevitably, the production of fresh evidence to see where we are today, because of course a lot of this is again some of the correspondence is relatively old. I mean the correspondence on which the AIT relied in January 2008, so more than 2 years ago, relates back to 2005 and 1995, sorry, 1997.
Yeah.
So quite some time back.
I mean, was there any fresh evidence put before the second tribunal?
My Lord, I'm not clear whether there was.
This would go back to the upper tribunal now.
My Lord, this would go back to the, as I understand it, it is the remittal was for a fresh second reconsideration before the Asylum and Immigration Tribunal, which is the role now taken over by the Immigration and Asylum Chamber of the
And what's
upper
the
tribunal.
what's the position about evidence at a secondary consideration?
My Lord, that is. My Lord, I would have to go back and look at the procedure rules, but in principle, especially on these issues, even the Court of Appeal has accepted that fresh evidence may be, in a case called Turgot, that fresh evidence may be admissible when it comes to the question of Article 3 risk, which of course even the Strasbourg Court will decide at the time it reaches it, despite the fact that the domestic courts may have made detailed findings of fact before it. But ultimately, our respectful submission is that these are all very fact-sensitive. The question whether these issues arise, and if they arise, how they are to be resolved, are extremely fact-sensitive issues, which are best left for the Immigration and Asylum Chamber of the Tribunal to resolve. And there is no ruling of law in the Court of Appeal's judgment, which in our respectful submission would prevent the appellant from establishing what he seeks.
Well, would it be permissible for the appellant to say that the Court of Appeal's approach to the issue of principle, viz., in what circumstances does a simple Chahal test apply and in what circumstances does an Osmond test apply, is open?
My Lord...
Or are there some points which should be said is precluded?
My Lord, yes, but insofar as that arises, the Court of Appeal, of course, was following a decision binding on itself as well in referring it straight back to Horvath. And therefore, of course, Horvath and the Court of Appeal in this case set limits for the approach the tribunal can take. There is no question about it.
But would it be open for them to the other side to argue that the Court of Appeal misdirected itself in applying the Osmond principles to a Horvath type of a case? The point that was made a little earlier by Mr. Hussain. I'm just a little worried that when the case gets back to the tribunal, much of this reasoning of the Court of Appeals will be treated as sacrosanct. In particular, the ones we've just been looking at.
But if all the facts are open, logically it shouldn't be and couldn't be, because you'll be dealing with a different fact substratum.
My Lord, yes.
Well,
but
I mean, I'm just wondering, listening to this debate, if the sensible thing isn't for us simply to adjourn this application, and then we can see what happens.
My Lord,
when it
I
gets
certainly...
before the upper tribunal.
I can see force in that. I've made clear the Secretary of State's position. I appreciate your Lordship's concern about what may happen when it gets back to the tribunal. Your Lordship may well think that that is the appropriate course of action.
well, it would certainly have the advantage that the kind of point we've just been discussing, namely the precise status of whatever it was that the Court of Appeal decided on issues of principle and on what assumptions or conclusions of fact wouldn't bedevil what happened before the tribunal.
But again, you have made clear, as I see it, on this third point also, that in the Secretary of State's view, the tribunal would be free and would be bound to apply whatever the correct legal principles to the facts before it, and wouldn't actually be bound to say the matter's already been decided.
My Lord, yes. Ultimately, it would have to decide what it says in the first sentence of paragraph 107. What is the test the Strasbourg Convention requires to have applied? And that's, we say, is in a sense the test it set out. The way it then describes it on an issue where ultimately it has decided that the reasoning of the tribunal below was so poor, both on the facts and on the law, that it needed to go back, in my respectful submission, is not something which should prevent the whole issue to be re-argued, possibly not on the basis that the Court of Appeal was wrong, because of course seeking to appear to appeal, the Court of Appeal to the Tribunal may not be the most attractive submission, but certainly the submission of the content of that submission, yes, I would accept that that's open to the appellant to re-argue before the Tribunal. My Lords, unless there's anything further I can assist you, Lordship, with that in outline is the Secretary of State's position.
Yes, thank you.
My Lords, I have nothing to say in reply about grounds 1 and 2. Grounds 3, sufficiency of protection, I'd like to make 3 short points. Mr. Riker goes to paragraph 63, Roman 7, and my Lord Clerk has the point that one needs to look at what the situation actually was before the tribunal, and we note that, by way of evidence, and we note that 63.7 includes the point made by Home Office officials that without special agreement on protection, this is page 19, without special agreement on protection, the appellant's safety, should he return to South Africa, must be doubtful. And that's the conclusion with which the tribunal expressed its assent. The second point I make is that Mr. Riker doesn't point to anything which justifies what we say is the introduction of an erroneous legal test of immediacy of risk as well as its reality. And with great respect to my Lord Mance, it is not the case that it could be argued that because the factual substratum might differ, that test disappears. The Court of Appeal have held that this is what the tribunal were required to do, to apply a real and immediacy test. That test, we say, is erroneous, and it is for this court, with great respect, to correct it. The third point is that as far as updating evidence is concerned, we say that Casey is entitled to success if on the facts as found by the tribunal there was no legal error. Incidentally, we note that the Pigu evidence was 17th of January 2008. The hearing before the tribunal was the 22nd of January 2008. So it very much had contemporaneous material before it. Those are my submissions in reply, unless I can assist my Lords further with anything.
Thank you. We're grateful to Council for their submissions and we'll reserve our decision.